This conference will now be recorded.
Hey, everybody. Good morning, good afternoon. Happy New Year to everybody, and welcome to the Cloud Communications Alliance. I'm Joe Marion, CCA President. CCA is really, and I'm really excited about what we have planned for 2022. We're soon going to be announcing several in-person meetings around the globe, as well as continuing our virtual meetings as we did in 2020 and 2021. But today, I'd like to welcome you to the third Cloud Communications Alliance European Conversation. The purpose of these webinars is to put a spotlight on the important areas of the European cloud communications world. Last year, we released our third edition of the Cloud EU Regulatory Guidebook. Members can find the guidebook in their members portal. The 2021 edition was expanded to include all the EU countries, as well as Norway, Switzerland, and the UK. We asked Access Partnership to present today a summary of the guidebook and to kind of bring us up to date as to what to expect in 2022. CCA has worked with Access Partnership almost since our beginning. We love the relationship because it helps us give value back to our EU members. Access Partnership creates policy, regulatory, legal routes to market around the world on behalf of some of the world's largest technology companies, as well as small startups and the public sector. Today, I'm honored to have Ilaria Benchivenga. She's the policy manager at Access Partnership. Ilaria advises on cloud communications policy regulations. She does analyses of ICT regulatory and licensing frameworks. She has a master's in law, and she specializes in the digital tech policy sector. Along with Ilaria, she has two colleagues, which I'll let her introduce later on in the program. Ilaria, take it away, and thank you.
Thank you for the introduction. I hope you hear me okay. Actually, you stole a lot of my words already because I also had an introductory slide, but you said most of it. So I will just crack a joke and hope that you appreciate that the background of the first slide is an actual cloud for the Cloud Communication Alliance member. But jokes aside, I'm here today with my colleagues Vadim Doronin, Senior Policy Manager, and Christel Erotogito, Policy Manager at Access Partnership. They will join me later. I hear double voices. Okay, they will join me later for the question and answer session because basically I will present. You can write down your questions in the chat, and then we will take your questions and respond. And I promise not to bore you to death, and that's why to keep you engaged, I have some questions for you. But no worries, because I am so proactive. I will also provide the answers to these questions. So first question is a rhetorical one. Are you part of the cloud service value chain? We assume you are, as part of the CCA, so like as members of the CCA, we assume you play a role in the cloud communications value chain. Second question is whether you're interested in deploying your services in Europe, and that's because, as already said, basically our guidebooks for the CCA have been focused on the European region. So if you joined here to understand how does it work for cloud communication providers in Singapore, that's not the right webinar for you. We can, of course, assist, but not today. And the third question basically gives you an idea of what we are discussing today, which are the legal ramifications of being a cloud communication service provider. So to understand whether you are subject or not to the Electronic Communication Regulatory Framework, which is harmonized in Europe, but some differences always occur. So the latest guidebooks basically focus on a general overview of the European Union. Then we have some country-focused guidebooks, which are Norway, Switzerland, and the UK. On the right, we have here basically just reported the index of each guidebook. They are mainly focused on the telecom aspects of the regulatory framework, but there are also some data aspects. And today we will focus on the telecom legal ramification. So why is this important, and how do we understand if a cloud communication provider is actually subject to the electronic communication regulatory framework? As everything in life, we have to start from the very beginning, so from definitions, and we have here reported the two ECS definitions. By ECS, I just refer simply to electronic communication services. The first definition comes from the framework directive, and the second definition comes from the recent European Electronic Communication Code. So you might wonder, why do we have two definitions? And you will understand it very shortly. The thing is that based on the old definition, over-the-top providers were basically excluded from legal ramifications and regulatory obligations of providing their services. Why? Because electronic communication service provider qualified as such if they provided services for a remuneration, so not free of charge, and consisting wholly or mainly in the conveyance of signal for which the provider would be responsible towards the consumer. So none of that, which sounds very technical, by the way, none of that was of interest for OTT providers. With the new definition from the European Electronic Communication Code, the definition is expanded. So not only the old one is still in place, but it also includes now internet access services and interpersonal communication services. By interpersonal communication services, we refer to communication within a finite number of persons, which are determined by the sender of the communications, and so in less fancy words, to OTT providers. And this could regard not only number-based international communication services, but also number-independent services. So the difference is whether in providing voice or messaging services within a finite number of a person, you use or not use numbering resources. So in case you find yourself falling into these definitions, you will have to have a careful look to the regulatory framework in Europe in general and in the specific countries of your interest, because basically most likely you will have to comply with a certain number of regulatory obligations. And we start here from the very first obligation that you will come across, which is the notification to the National Regulatory Authority. National Regulatory Authority could be regulatory bodies, ministries that depend on the specific country. The notification is always required, and it does not give you a specific license. It just allows you to operate under what is called the general authorization regime, which basically comes with numbers of rights and obligations. We have summarized here in this table where the notification is required. So overall in Europe, it is always required. It is a straightforward procedure, but it's also not harmonized, meaning that you have to do it on a country basis. Each country has its forms, their contact to be submitted notifications to, etc. And the UK is the only country that has this obligation included in the regulatory framework, but in practice is not applicable. It's not required. And you might think, okay, so in the UK I can provide my electronic communication services and be exempted from all obligation. No, that's different. You don't have to notify, but of course you will have to work and be compliant to their regulatory framework. And there is also another thing. If you are a cloud communication provider and you are a number-based one, so you use numbering resources, you might think, okay, I want to operate in Italy, so I've been told by my regulatory partners that I have to notify in Italy. I'm notified now as an electronic communication service provider, so I can use the numbers that I need to provide my service. That's not true, because numbers are considered by regulator as a scarce resource, so they have to be allocated by the regulator. And in order to have allocated numbers, you have to undergo through a separate licensing. So the licensing for numbers and the licensing and the notifications are not the same process. Before you start notifying, you will see that life doesn't come without challenging, because you might notice that you might be required to be registered in the country, so to have a local presence. Based on the electronic communication, the new electronic communication code, this requirement should be deleted. Like basically, you should be able, if you are registered in any European country, you should be able to notify in other European country without having any local presence. But exceptions could always be found. So that's something that should be analyzed on a case-by-case basis. And in the guidebooks that we have produced lately, we haven't identified some example like Norway and Switzerland. Okay, Norway is a bit more stringent because they want the company to establish a branch or a separate company in the country, while Switzerland only asks for a correspondence address in the country. But let's go back to the numbering aspect, which I believe is the most telecom-oriented aspect of this webinar. I'm sure everyone is used to think that the numbers are infinite, and they are in the mathematical world, but not from a telecom perspective. As I said already, they are a scarce resource. So I cannot just go and use whatever numbers. If I want numbers to be allocated to me, where me is a company, I will have to go to the National Regulatory Authority and apply for these numbers. And then I will be able to assign them again to end users. And this is the process which is described in the first row of this graph. However, there are also two more ways of obtaining numbers, which can be described as transfer of full rights or transfer of partial numbering rights, also known as suballocation. And the difference between these two processes is in who is the party that has actually the regulatory obligations. In the transfer of full rights, we have an operator which has obtained the numbers from the National Regulatory Authority in the first place. And this operator transfers full rights and obligations of numbers to another operator. So it's like basically operator one doesn't exist anymore from a regulatory point of view. And then we have the other transfer or suballocation, where basically operator number two simply manages the numbers and can assign the numbers to end users. However, the party responsible towards the regulator of all the obligations connected to numbers is the operator number one. So there is still a connection of the operator number one with the National Regulatory Authority. We have also included a small note about the fact that number trading is generally not allowed, meaning that the regulator will not be happy, and neither they will allow you to receive being allocated number if the purpose is just to make a trade out of this number that have been allocated. So in this slide, basically, I have explained from a regulatory point of view how to obtain numbers and the three ways. But once numbers are obtained, once numbers have been allocated, then the operator that has the number needs to be mindful of some regulatory obligations, such as, for instance, portability and emergency carriage. As to portability, I'm sure that each one of you has ported their numbers at least once. Otherwise, I'm the only one having a problem here because I ported my number several times. And by portability, of course, we mean the fact that we can maintain our personal number, changing the operator that grants us the telephone service or the service that we have access to through this number. Basically, portability based on the regulatory framework in Europe must be covered for geographic and non-geographic numbers, so fixed numbers as well. I wonder who on earth uses fixed numbers except for businesses anymore, but apparently there are people, they do use fixed numbers. And portability shall be basically completed within a couple of business days. And in this presentation, we've been quite generous because the practice is usually, from a regulatory point of view, that the portability should be completed in one business day. And we also want to trigger your attention on VoIP, Voice over Internet Protocol Services, because in this case, if I provide, if I provide services through VoIP, do I have to ensure portability of numbers? Well, if the numbers that I use come from the national numbering plan, then yes, most likely I will have to ensure portability. By the way, by national numbering plan, we refer to these plans where regulators have basically identified which specific range of numbers are used for what specific type of services. And but what is challenging is that in some jurisdiction there is no definition of VoIP, there is no specific range of numbers, and so there is not a one only answer on whether portability should be ensured for VoIP or not. And it's something that we should study and review in the specific regulatory framework. The other obligation is the emergency carriage. So it is a right for all users of public available telephone service to be able to call, for instance, the European emergency number, which is 112, and also to call any other national emergency number. Calling this emergency number should be ensured by the operator free of charge. I don't pay if I call any of these numbers. But what is challenging for cloud providers who, for instance, offer voice services, number-based voice services, is that in most jurisdictions, it is, and even in the new electronic communication code, it is required to basically provide the ID caller location. What does that mean? That the operator needs to be able to provide the name of the caller, the location of the caller, and sometimes this is not technically feasible. So in some regulatory framework, you will find that they will refer to whether it's technically feasible or not, and what measure you can apply, you cannot apply if it's not technically feasible. So again, as before, there is no one answer only. Even if in Europe the regulatory framework is more or less harmonized, it's always something that policy analysts or your legal department will have to check on a specific base. And same consideration for VoIP services as we did it for the portability. The next two slides, which are VIT policy and dispute resolution, are a bit less, actually, telecom focused. But it's something that we have addressed in the guidebook, so I just want to give you a very short overview. For VIT, the value-added tax policy, we have studied it from two perspectives. So provision of services to private citizens or provision of services to businesses, to business. In the latter, basically the applicable principle is that services are taxed at the customer's place of establishment, while for provision of services to private citizens, it's actually quite good that most European countries have adhered to the MOS scheme. the mini one-stop shop scheme. I think that, I mean, you might not be interested, but I think that this is a very funny name. The scheme basically allows you to declare VAT via one European country only, but providing services in multiple countries, so making your tax lawyer's life way easier. And for the dispute resolution part, again, we have a double angle. Dispute resolution in case the dispute is between an operator and consumers, or in between operators. Basically, in the first case, the responsible body for the dispute resolution will either be the NRA or an independent body. And what they will offer you is an alternative dispute resolution. So the decision is not binding, and you can always refer to court after. And in case of a dispute resolution between operators, more likely the NRA is the responsible body, but again, you can refer to court even if their decision ideally are binding. You can find detailed information of all this in the guidebooks, analyzed by countries, for instance. We have two more aspects which are more telecom. The security incident requirements. You might find these coming either from the telecom law or the data protection law, referring to GDPR and the e-privacy law. The security requirements we are referring to are for protection of either personal data of users, or for the integrity and security of the telecommunication service and network itself. So meaning that an operator must ensure that their service and their network is able to function, in like a more simple word. A measure to be basically imposed on each regulatory framework could be the protection of this personal data and telecommunication service and network, sorting of any incident that can happen, and information of the authority and or users of these incidents. And basically about the last case, like informing the authority or the users, timeframes are different depending on how important was the incident that happened. And so again, this is something that needs to be analyzed on a case-by-case level. And then we have the very last aspect that we have analyzed in our guidebooks, and that's something that relates to all of us when we travel around Europe, and it's the roaming. So, for instance, I was in Italy for Christmas. I'm Italian, and I was simply using my UK SIM card. Why? Well, because my operator applies the roam like home principle. So basically, within Europe, operators are not obliged to ensure roaming services, but if they do, they will have to apply the roam like home principle. So they will not have to charge, they cannot charge more their users for just being in another European country. And extra EU, the situation is different. This principle does not apply, and there is a duty to negotiate interconnection agreements. Then, small table again to sum up what we have analyzed deeply in our guidebooks, which is that Norway and UK applies the roam like home principle. Switzerland doesn't, but they also have, of course, national regulations to ensure that users are not subject to very high and unreasonable fees. As was said at the beginning, basically the guidebooks were produced for the CCA members by Access Partnership, leading tech consultancy. Myself, Vadim and Krista that would join me shortly are part of the compliance and market intelligence team. So we are the main readers of reports like guidebooks and any research and investigation that will basically produce for cloud communication providers very actionable advice. And not only we are we do a very thorough regulatory advice work, but we can also ensure market access, meaning that we can work on the licensing that you might need in the different jurisdiction and perform the licensing for you and with you. And once any licenses, authorization has been obtained, we can cover also the compliance support. So any regulatory obligation that comes from holding a license, having notified the regulator, we can basically overview them and be your partners in ensuring that you are compliant, in compliance with these regulatory obligations. When you speak, you don't have perception of how fast you actually speak, so I hope I didn't rush it too much. Anyways, thank you very much for joining today, especially because if you are based in Europe, it's the end of your working day. And if you have questions, I'm here with Vadim and Crystal, that I don't know if they are showing their faces. And that's it. I hope you enjoyed it. Joseph, you're on mute.
Thank you. Everybody, thanks for joining us. If you feel free to turn on your webcam, we did have one question texted. Scott, turn on your camera. Why don't you ask it directly to Ilaria? Scott Helms, you still there?
Yeah, sure. Sorry, I had to get to the controls.
There you go.
Hi, yeah, I just wanted to make sure that that the rules around telecom are only applied to phone numbers. We're not talking about IP addresses or ASNs or any of the other kinds of numbers that we might use.
Yeah, Vadim, go ahead.
Thank you very much. So answering you to your question, the main thing here is to look into whether or not numbers are from national numbering plan. So IP IP addresses are not. So yeah, this would not be affecting use of IP addresses. So, but it's very important to bear in mind here that we're talking here about number dependent and number independent interpersonal communication services. So if you are using numbers from national plan, then numbering plan, you need to comply with the requirements, including portability of numbers. Yep.
Thank you.
Great. Ian, you look like you're about to say something.
Well, no, I raised a quick question in there, and it was about the notification to authorities of data breach and that sort of thing. And the suggestion there was that by country there is a different requirement depending on the severity or type of the breach. Is there a matrix in each country where you understand the principles of when we must respond to any data breach notification, etc.?
Yes, it's on a country basis, but I see that Vadim is eager to jump on this question. So, Vadim.
Thank you very much for putting me on spot. All right, so I'm sorry you don't see me. Something has happened to my camera, but at least you can hear me, hopefully. So so here we need to bear in mind potentially three different types of notifications for incidents. So the first one is general, that is not necessarily has anything to do with electronic communication services. This is under GDPR, right? So as you know, there is a personal data breach. Controllers need to inform authorities, potentially subscribers, end users, customers. Then there is a separate e-privacy directive, right, in the European Union that requires notification to the authority of security breach of data or personal data. Usually what happens is that this e-privacy and GDPR come together, right, because they cover the same topic. So you would be filling in one application or notification form and sending it out. So answering your question, the authorities or regulatory framework may have different requirements, criteria, in which cases you need to notify, etc. But usually, based on our experience, in case of a personal data breach, it's rather likely that they will almost always would like you to notify them about the incident, etc. But usually it's not a big it's not difficult. The forms and contact details are publicly available, and you may discuss with your data protection officer involved. Usually the time frame is quite short. It's either as soon as possible or at least within 72 hours. So once you are aware of the breach, so you really need to talk to your processors, which usually electronic communication service providers are processors, and it's a long conversation. But generally speaking, there's a requirement to notify in case of a breach of data protection, personal data. And the second thing I wanted to emphasize is that there is a separate matter that is under electronic communication code directive, and this has been implemented, and it has previously been also implemented in a national legislation. Is then if there is a outage or there is a security breach that has not direct implications to data, personal data. For example, in case you had a outage, right, or there was a breach of network which made your network go down, and your customers didn't have a chance to access emergency services, etc. So this is separate from personal data breach, right? This is the second aspect when you need to notify national regulatory authority. And in this case, as opposed to personal data breach, we're talking about telecommunication regulatory authorities such as Ofcom, Bundesnetzagentur. So this is a separate second type of breach of security that providers of service of electronic communication services must notify to the authorities, as well as in some cases notify to affected customers.
So you're saying that if my network has lost the ability to provide telephony, and one of those telephony services is to call the emergency services, that's a trigger for me to notify that we are not in a position to do that?
Yes. So, at least to consider that you are at their obligation to notify. So different jurisdictions like Germany or UK have different aspects or different number of end users affected. But usually if your customers didn't have a possibility, and you are providing emergency services, and they didn't have a possibility to have access to emergency services even for a short period of time, this is a requirement to notify Ofcom or Bundesnetzagentur, depending on which country the outage took place. So yes, answering to your question, yes. And this is separate from personal data breaches. Okay. Yeah, but
Ian,
again,
it sounded like you were referring to like DDoS attack.
Again, the crucial here is whether or not your customers have had a chance to have access to the services, right? So yes, so if the system is down, or your customers cannot access it, then you need to notify the authority. But again, the devil is in the details. That there are some. It's very detail regulated, right? So, but usually the perception is if emergency services were down even for a short period of time, you need to inform the authorities because of the health and safety, of customers, etc. But yeah, the requirement is there for sure.
Yep. Here in the States, we have a similar thing with E911 regulations. I mean, if your customers can't get out on, the E911 is the emergency number. If they can't get out on E911, you have to notify the authorities. Very similar. Laurent, are you?
Hi, Joe.
Hi. Good morning. Oh, good afternoon.
Yeah, good evening soon.
Bonsoir.
Bonsoir. Well, actually, I missed the first 15 minutes. I'm really really wanted to participate to the whole webinar. So I guess I'm gonna have to rewatch it through the recording. But I mean, the idea was the idea for me was really to better understand what were the constraints of being a service provider in France, for instance, and providing numbers in Germany, and doing portability for customers that are in Germany. Can we do that? Do we need to have a license in Germany? Do we need to have a license, telecom operator license in every country? How is the regulatory landscape preparing for that? I mean, Europe is complex. Most of the cloud communication platforms try to be global and provide services to countries, to customers in many countries. Do we need to have that license in every country, or can we use a supplier like Voxbone, for instance? Or what's the plan for the future on that?
Here as well, because I think it'd be quite useful to have some case studies, some real-world examples of where where licenses have had to be had and where deals have had to be brokered, etc., so that people looking in from the outside get a feel for the scope, the size of the job, really, because it is a bit of a black art, isn't it? It's why people like Access Partnership here, because they're the people that know how it works, right? But to give people a good idea, I think some case studies would be quite useful.
Hilario, the question though, I think that Laurent, that I heard you ask is, will one license do, or do you need one in every jurisdiction? Did I get that right?
Based on some previous experience that we were having, so first of all, if you're using numbers which are from the national numbering plan, most likely you will need a license in the specific jurisdiction because they're part of their national numbering plan. But I've also encountered some a situation where a company was using ITU numbers which were non-geographic and non-national, and they could be used regardless of the specific country, but because they are identified like that. So basically they are not bounded to a specific geography, to a specific nation.
Yeah.
But it is also
I'm more thinking about that. Like, for instance, I'm in France. I have a customer that has 500 sites. 300 are in Europe, and 200 are in France, and 200 are in Italy and in Germany and the UK, for instance. If I want to respond to that customer, I need to have a license in Germany, in Italy, and in the UK also.
Yes. Yeah, you will have to have a license in each and every country. And I also sense, again, as he's asked, that Vadim wants me to give him the word. Vadim is one of our colleagues that has a lot to say, and his reports are very detailed. So that's why he always has to build on top of what we say. Go, Vadim.
Again, thank you very much, Hilaria, for putting me on spot. Right. So no, it's all correct. So Hilaria has correctly advised you that what happens here is that when you provide electronic e-commerce services, right, there are passporting rights. So, and I don't want to go into a lot of details here, but many customers ask, like, we are established in France, right? And let's say we provide services like, in all across Europe. Then in some, or in e-commerce in general, there are passporting rights. So you are subject to the jurisdiction where you are established, right? So for finance, banking, like maybe this is the reason why we had 2008, that nobody actually considered responsible. But if electronic communication services or telecoms, it's not the case. So if you're providing services, electronic communication services to 200 customers in Germany, you are ultimately providing services in Germany, and Bundesnetzagentur has jurisdiction over your activities, right? The same is with Italy, the same is with Poland, UK. So, well, UK is no longer part, but generally speaking, you see what I mean, right? Yeah. So when you provide services in any of the European Union jurisdiction, you are subject to the requirements, and you don't need a license. And I just bear with me. You need a notification, right? It's very simple. And BEREC has recently had some consultations on this subject, how difficult it is to send this notification, etc. Generally speaking, it's not the most difficult part of your agenda. All right, you just fill in a form, you submit it to the right person, and generally speaking, this should be it. You should get some response like, oh, everything's fine, you're registered. In France they have RCEP has abolished this registration, but in Germany it has not. But it's very simple, right? So it's nothing precludes you from doing this. Sending an application form in Italy is a bit more complicated, but Germany, in many other jurisdictions, it's not a big deal in Europe. Having said that, later on you will be subject to a lot of requirements that Ilaria just mentioned during today's call. But again, considering that this is Europe and it's again the devil's in the details, you still have to comply with those requirements, but they are very harmonized, right? What is not harmonized really is the use of frequencies and use of numbering. And again, there is a little bit of issues about number assignment, transfer of numbering resources, all that matters. But again, this is something that if you have a partner, you really need to discuss with your partner who is assigning you numbers. And I'm talking very in general here, not specific country, whether or not the sub-assignment is allowed. Right? What are the responsibilities you should take upon yourself, and what your partner is taking them? Whether portability is done by you or by somebody else. Usually, if you are providing a service, right, you have a contract with your end user, and under the contract you are responsible, right?
Yep.
So and the problem is, even if you manage to insert some clauses in your agreement that you are not responsible under this and this, there is public law, right? So you, under public law, the authority will say, oh, but no, but you are electronic communication service provider, you are responsible. So it's very, very, very important to see your obligations, to what extent you are responsible, and whether you can rely on your partner to make sure that the network functions, your services are provided timely, and with the necessary under certain requirements that are fulfilled under the existing applicable regulatory framework.
So
right?
how the way we do it for the moment is probably, like, for many of us, using people like Voxbone or DID.net, I think, or others like that. It means that in the long term, it's not gonna work anymore, right? I mean, we're gonna have to be local and respect the regulatory landscape of each country.
Laurent, can I speak here quickly? This is Isabel Doe from Bandwidth of Voxbone, as you mentioned.
Hi.
As you might have noticed, we've been driving quite heavily last year already, notification audits. So yes, we fully support that you, as a customer, as an ECS provider, notify and are in compliance with national regulation. As you also know, we've been more forceful in some countries than others. This is mainly because some regulators are a little bit more active on enforcing this than others. So, but the idea is that yes, we will be guiding our customers with these guidebooks, these how to notify guidebooks, and more turnkey support. So we built out a compliance team as well to be helping our customers with this, to notify more countries, so that you are notified in all of the countries where this is required.
Yeah, I think we had problems with Luxembourg and Switzerland.
Luxembourg and Switzerland are quite difficult countries indeed to notify, especially Luxembourg with the
few customers. Happily, there are few customers there.
Yes, indeed. Luxembourg is a bit particular with the EARCOM requirements and everything, but like Ilaria mentioned earlier, they're looking to harmonize everything to make the process of notifying a lot easier. And yeah, we're also quite in a lot of discussions with the regulators themselves to give the customer's perspective, and also to give our past experience of driving these audits to serve your interest in this case. But yes, unfortunately, it's a necessary evil. And
but the good news is, if I may, that this is doable, right? It's just it's a mainly administrative burden, right? That it's a
Absolutely.
question of cost. But again, that the EU law is quite harmonized to a certain extent, and again, it's just simply something that people need to pay attention to comply and to see, right? And again, the question more, the trend is more into protecting consumers and users,
Yeah,
right?
of course.
So this is the trend that where we're going into, and unfortunately, and this is really unfortunately, and especially this is a question for some American customers, that but if I comply in France or Germany, that I guess that's it, right? Yeah, and I guess this is not right. I'm not an expert on US, but yeah, I know in the United States they have also states, and there are some commissions, etc. So unfortunately, we don't have in the European Union, or fortunately, I don't know, depending on which person you're talking to or with, we don't have an authority, right? Ben Barrick has more or less, functions of consultancy. They advise, they listen to by the commission, they work with the commission. But again, it's not a regulator as such, right? They don't, there is a lot of discussion now on harmonizing this notification process. So you have, the idea is, ideally would be that you're not notified to one, and then they share, like you just fill in one application form, and then send it to one authority, and then they distribute it to all authorities where you want to be providing services, so you don't need to send 27 or 25 notification forms. But again, this is something that is going on, and yeah, but for the moment there is a issue is that you need to be notified in these jurisdictions where you provide services.
Okay, thank you.
If they go, as this is spoken as an American, but if they go to one form and that notifies everybody where you want to provide services, that would really be harmonizing. I mean, I like the way how these regulators throw around the word harmonizing. Right now, it's not harmonized, but what you suggested would be harmonized.
And I think
Yes.
that's definitely what the industry is asking for, right? Barrick already maintains the record of all notifications with the national, or they're supposed to, all the national regulators. So I guess it's a political question, but it would not be for customers. It would be an easy step to notify and just maybe take the countries where they want to notify in, be able to update that through a common portal and everything. That's definitely what the market is asking for. Now, whether or not it can be done on the EU level in short term.
Is this something, Joe, that the CCA should be looking to lobby for?
Yes, if we could figure out exactly who to lobby, but the answer is yes. It's a little bit, sometimes we find the EC a little confusing, to tell you the truth.
I drink almost anything. Yes, I will not forget it today.
I think we have some cross conversation here. Any other questions? Anybody else?
Just Joe, maybe how can we get access to the recordings and maybe to the contact information of Alaria?
Sure. Well, what we're going to do is we're going to send out a follow-up email to everybody who registered for today's event. That'll have a link to the recording, a link to the PDF, and Alaria's contact information. So that'll all be in the email you'll receive later today or tomorrow. Well, for most of you, for tomorrow morning.
Joe, somebody did send in another question.
Go ahead. Alexandra. Is Alexandra, are you still there?
Yeah, hi everyone. Thank you so much.
Turn on your camera if you'd like.
Sure. Hi everyone. Thank you so much for this conference. It's very instructive. From our experience, I think that the main issue is not so much having being declared, because as you said, it's pretty straightforward process in most of the countries. But the real issue, and I heard my Volkswagen colleague talking, the real issue is that when you need to really do the work and go and get your ranges. And from the discussion we had at Cantu with the different regulator in Europe, there is a gray zone where actually you don't have enough numbers that justify the price of having the ranges of your own and having them interconnected to the main tier 1 carriers and collected it yourself. And there is a gray zone. Up until this point, you can get numbers and provide those numbers to your clients. But after a certain amount of DID, then you will have to do the work. And since you mentioned that the devil is in the detail, I think that's the most, difficult point to assert. And since it comes with quite a lot of investment, it's really a strategic decision that you need to go to. And it's also very different depending on the kind of DIDs that you want to get. In France, you are not supposed to reallocate non-geographic number, but you still can do with geographical number. But I mean, the investment that you have to put on the table to get those non-geographical number connected is quite high. So there's still a lot of people doing, getting numbers from tier carriers that have done the work. So yeah, the devil is in the detail, and this gray zone is still I think very much alive, or very much real. What's your take on that?
That's correct. So, so Vadim here. So yeah, you're absolutely right. So the issue here is with the European regulation that the numbering is mainly with the national states, right? And unfortunately, assignment. So as Ilaria said, generally speaking, there are 3 ways of getting numbers, right? The first is directly from the authority. The second one is a transfer, and another is sub-assignment, right? So in the case of a sub-assignment, the issue is whether and to what extent you can use numbers from another operator, right? Whether this is allowed, first thing, and what are their obligations, right? Whether your original assignee who got numbers in the first place is responsible for everything, or you carry some responsibility. And what sometimes happens is that numbers are assigned, to several layers, right? So you get 3-4 layers of numbers, and this is what happens is that authority loses control of their numbers. Yep. And this is what they really don't like to have, because the question about knowing your customer, who is responsible, whether, there are a lot of regulatory issues that come into play, right? About lawful interception, data retention, of what exactly we're retaining data of if we don't know who is a customer. So answering your question is, there is a lot of uncertainty here. Again, each country on number regulations has to be looked into directly. What I can say, there are different, like Germany, in my view, has very detailed, but at the same time maybe a bit burdensome regulations on the use of numbering resources. Other countries have less restrictions. So again, in this case, we can just either look into regulatory framework in each country and try to comply, by the way we described during this webinar, or another way, as you go and lobby and advocate and try to see if we can have one harmonized regulatory framework on the use of numbering, which would be great. This would make all our lives, including myself, much easier, I guess.
Yeah, I understand. For example, the Netherlands has a very good number porting, if you will, system. Yet the UK is a bit of a mess.
Apparently, in France, sub-allocation is going to be it won't be allowed. starting January 2022, I think, 2023, in a year from now. And that's a big market, so yeah, it's going to be a mess.
I think
we will look. I think CCA we will look into this. Maybe there's a way we can, be your voice, if you will, on this. I think it's an issue that an organization like CCA should be looking at. Anything else?
And I just wanted to highlight, of course, everything comes with a cost. So when you obtain numbers, of course, notification and provision of services are relatively either free of charge or not really expensive. But when we talk about using of numbers in applying for numbers, and the recurring fee can be quite significant, and depending on the type of numbers as well. So this is something that is important to bear in mind. Not only obligations, but also fees which are associated with the use of numbers. And especially if I'm not even talking about premium type of numbers. This could be a lot of different types of regulation.
Yes, of course.
Thank you. Access Partners, thank you. Ilaria, thank you. Dorian, thank you. Crystal, thank you. You guys were great today. We're going to have another one next week around the same time. It's going to be focusing on cybersecurity. But I most importantly want to recommend that you sign up for the Cavell CloudCom Summit. It'll be in March. And then the morning after the CloudCom Summit, March 10th, we're going to have a breakfast for CCA members in the UK at the same hotel that the CloudCom Summit is going on. So, and if you register before the end of January, there's no charge for CCA members. So get on the website, register for that event. Want to thank you all. Hopefully you'll join us again next week. Again, Access Partnership, thank you very much. Everybody have a great rest of the day.
Thank you.
Cheers,
Thank you
all.
for joining.
Thank you very much.
Bye, guys.
Thanks.
Thank you, guys.
Thanks. Bye-bye. Bye-bye.
Bye.